A very good evening to all of you. So tonight, we are starting a bit early so that I can finish and go home since I'm still at my office. We will be doing two main things tonight. So first of all, we use a few minutes to quickly brush up our knowledge of the doctrine of judicial precedent in legal system and legal method. When we are done with that, I will take you to criminal law for us to do some general revision in criminal law, using some questions that we used last year to help those who wrote last year. So that is what we'll be doing tonight. So you move very fast so that we can finish. Just at this stage, you have done the reading and all that. So this is just a brush up, just going over what you know already. But just in case you still need to do a lot of reading, then it's recommended that you look at the 1992 Constitution, of course, the relevant provision on the court structure, especially like the Supreme Court and the Court of Appeal. Yeah, and then we also look at my book with my colleague, Mr. Kwarteng of Central University, and then you look at the late Professor Quansah's work, which is also useful. And there's an article which Justice Taylor of blessed memory also did, Judicial Precedent in Ghana, in the review of Ghana law, is also a useful material. So if you look at that, I mean, you should be fine. Okay, so without wasting time, we remember that by judicial precedent and stare decisis, our attention goes to the fact that when courts are deciding cases, courts are guided by previous decisions, especially so where the previous decisions are relevant to matters which have come before them. The court will draw inspiration from them. So within the common law tradition, this system of making use of past decisions and all that, or making use of what you call like stare decisis, simply mean like sticking to already established decisions. We say that the standby matters already decided, so that is stare decisis. And if you look at it, it's not something unique. It's consistent with our human reason and our everyday discourse and interaction, that where you have you've had like a problem before, and that problem, for example, comes up again, or a similar one comes up, you don't have to reinvent the wheel, as it were. So that is the basic idea. And as we know, it's quite common that very central to the common law tradition who developed with the Norman Conquest of 1066 in England and Wales, which eventually spread through the colonial ambition of Great Britain in the various colonies, and gradually also got to our part of the world, is the judicial precedence. So stare decisis et non quieta movere, meaning literally that you have to adhere to what has already been decided and not to unsettle established things. And that is the policy which underpin judicial precedent, that where a matter has been decided, then the court should stand by that. The court should not ignore that which has been resolved already. But of course, if we look at our jurisdiction, we know that appropriate circumstances, like the Supreme Court, for example, as we met yesterday or in our previous discussion of some of the questions, that if you look at the Constitution, Article 129 clause 3, for example, that the Supreme Court, despite the fact that is bound by its previous decision, may also depart from it where it deems it fit and appropriate to do that. So that is there. Again, we have to remember that stare decisis is different from res judicata. That is estoper per rem judicata. Estoper per rem judicata simply means that a matter which has been decided cannot be relitigated again. And it is consistent with the public policy that litigation must come to an end. Litigation should not become like unending enterprise or adventure, or so as to make it like a persecution. So once a matter has come before court, then res judicata says that that same matter cannot be re-litigated, especially so if the same facts between the same parties or those related to the parties are litigated and all that. So that is res judicata. And just for purposes of a reminder, in criminal law and also in the Constitution, if you remember, if we go to Article 19 of the Constitution, there is something we call the rule of what they call the double jeopardy, right? The principle of double jeopardy. If you go to Article 19 of the Constitution, and especially, just trying to close. Yeah, so it simply says that no one shall be punished twice, right, for the same offense, meaning that if you have been tried in respect of a criminal offense and you have been punished for that or whatever, then that same case cannot be brought against you. And if you look at the Article 19 of the Constitution, we call that like the rule against double jeopardy. Of course, it is analogous to res judicata in civil litigation. Res judicata, as we've said, something which has been decided before should not be re-litigated and all that. I'm talking about in terms of the facts and order between the parties. But that is not necessarily the same as stare decisis, because stare decisis is talking about a principle of law which has been propounded or laid down should not be ignored. Of course, in Ghana, unless there's a reason, let's say for the Supreme Court departure, or when any of the rules that we know are not relevant. So res judicata, again, simply to the effect that the parties to dispute and their successors, previous and assigns, are bound by the final decision of the court once the period for appeal has passed, and they cannot relitigate the issue decided by the court. So if we look at it, res judicata relates only to the original parties in the dispute and to the decision of the case only. The decision of the case is different from the principle of law, for example, laid down in the case. The principle of law laid down in the case is what will count for purposes of judicial precedent. But in terms of the decision on the facts, that is what will count for purposes of like the res judicata, as it were. And of course, res judicata has no relevance with respect to, the laws which guide the court in making decisions. It is only relevant between the parties and those who are related to them, and those that they will transfer their interest to and so on. Other things that we have to know. So just to recount, differences between stare decisis and res judicata. Res judicata applies to the decision in the dispute, whereas stare decisis operates so as to the ruling of the law involved in the decision. So the decision in the dispute in terms of issues of facts, right, which arose in that particular case, and what the court said, those things are binding. For example, if it's a land litigation and the court has litigated that the boundary lies at this place and not that place, now that is a factual matter that is binding between the parties, their privies, their assigns, agents, and so on in the foreseeable future. However, if, for example, the court decided or established a principle that in a land transaction, the identity of the land should be established. Otherwise, you cannot get a declaration of title. Assuming that is what the court developed, that becomes like a principle of law, and that would operate as a judicial precedent subject to the other principles which govern judicial precedent. So let's keep that in mind. Again, res judicata applies to all courts, right? If you say it applies to all courts, it doesn't matter the particular level of the court. Even if the case was decided by the smallest court. Now, let's say that if a case was decided by a district court, right, in a certain village, and that same case or facts, which are just like that, are brought to the high court in the region within which that village was established and all that. Now, the decision of that magistrate in that village will operate as res judicata so as to let the high court decline jurisdiction, to say that we are not going to allow it to be relitigated because that matter has been decided. So that is why we're saying that res judicata applies to all courts. So let's keep that in mind. And again, we want to say that it binds only the parties and their successors. But if you are not a successor or you are completely stranger, unrelated, res judicata has no effect on you. But stare decisis applies to everyone, including those who come before the court in other cases. So that is the difference. So the same case may serve as a precedent. And at the same time, the factual aspect of it between the parties serve as a res judicata. And the res judicata will be applicable to the parties to the case, their successors, their previous and assets. Whereas the principle of law decided in that case will apply to everybody so far as the person gets a case which is similar to the one which was decided. So that's another thing that we should keep in mind. And again, of course, stare decisis, we should say, is brought into operation only by decision of the superior courts. As I told you, for res judicata, in a district court, sitting somewhere can decide a matter, and that will operate as res judicata so as to prevent relitigation. But stare decisis applies only to superior courts of judicature, and they are considered as courts of record. And that begins from the High Court, the Court of Appeal, and the Supreme Court. So it is the decisions of these superior courts on points of law which can serve or operate as judicial precedent, stare decisis as it will. And again, res judicata takes effect after the time for appealing against a decision is passed. So when a judgment is given, there's a period for appeal. If it's a substantive, if it's like a final judgment, you have, let's say, 3 months to appeal, interlocutory, 21 days. Now, when the period for the appeal has elapsed and the losing party has not appealed, then that losing party and his successors cannot go and relitigate the matter again. Res judicata will kick in. Stare decisis, on the other hand, operates at once. If a decision is made by the Supreme Court or the Court of Appeal, depending upon the principle of law and how novel it is, it takes immediate effect. So that if Supreme Court gave a certain decision today in terms of points of law and is changing the law or is propounding something different from that which we know, then even in the afternoon or 1 hour after that, or even 10 minutes after the pronouncement, if there's an ongoing case and the lawyers had the benefit of the decision which the Supreme Court has given, they can right away apply the new decision. So just to reinforce the point that precedents or judicial precedent, stare decisis operates at once. It doesn't have to wait for the period of appeal to be. Of course, there is a little bit of jurisprudential debate, but we don't need to waste a lot of time on it. An argument is made. Is stare decisis interchangeable with judicial precedent? Number of schools of thought, yes. Some will say that the two are interchangeable. Others will say that not necessarily, but I think that it's not something that we need to waste a lot of time on. If we look at the serious article that, for example, we have referred you to, you notice that you will suggest that stare decisis is a general philosophical concept which reflects the human tendency. That is how human beings are. For example, just now, before I started the class, I told you that when we finish this class, and there is time, we are going to move straight into criminal law revision. And I'll be using the questions and the materials I use for criminal law revision. Now that is, if you like, a practical example of what Taylor is trying to suggest, that the stare decisis is a general philosophical concept embodying normal human tendency, because I'm trying to apply what was done, let's say, last year, because what we are confronted with this year, the same examination, the same circumstance. If something was, for example, used in preparing for last year, I consider it equally necessary for this year. So in a very good way, that is a reflection of, if you like the stare decisis. And that is why Taylor would say that is like the philosophical as it were. Yeah, I know some of you would like to ask questions, but I want to, when I'm doing normal explanation, I want to finish before, otherwise it will interrupt the flow of the discussion. So just hold on. Yeah, so that is that. But I wanted us to also, just let's look at the Black's Law Dictionary again. I think over here, I have like the 9th edition. Yeah, so if you look at the Black's Law Dictionary, the 9th edition I have here, page 1537, for example, it says, and I quote, stare decisis et non quieta movere. That is, stand by things decided and not to disturb settled things. And then it will go on and then just refer us to stare decisis, who says that to stand by things decided, the doctrine of precedent. So if you look at the Black's Law Dictionary, it says that, so after the same place where it explains stare decisis as to stand by things decided, it goes on to say that the doctrine of precedent, under which a court must clear judicial decisions when the same points arise again in litigation. The same point arise again in what? In litigation. Good. So, and then he will, the authors of Black's Law Dictionary will actually cite other sources and make the point, quote, cite the book called The Making and the Use of Law Books, quote, the rule of adherence to judicial precedent finds its expression in the doctrine of stare decisis. This doctrine is simply that when a point or principle of law has been once officially decided or settled by the ruling of a competent court in a case, which it is directly and necessarily involved, it will no longer be considered as open to examination or to any ruling by the same tribunal or by those which are bound to follow its adjudication, unless it is for urgent reasons and in exceptional circumstances. Yeah, so therefore, we will say that stare decisis is used interchangeably with judicial precedent. And if we look at authorities like Rupert Cross in his important work, Precedent in English, he seems to endorse that position. And again, if you look at the Husband's Laws of England, it also seems to endorse that position. So you don't need to waste time on whether they mean different things, all right? We don't have a luxury of time. We have just about 10 minutes, 10 days to go. Okay, so requirements for operation of judicial precedent. For judicial precedent to operate, two key things need to be understood. First, we are talking about having series of decided cases, and two, we are talking about the presence of established positions or principles of law in cases. So for example, if you had a general question, which of course it will be a bonus or it will be a give up. Well, anything at all can happen. Even if they can ask you to do a question on source of law, why not? You could be asked to also discuss judicial precedent in one way or the other. Now, to have judicial precedent operate, there's a need for law reporting. So law reporting is important because if cases decided by the Superior Court, Supreme Court, Court of Appeal, High Court, if they are not reported, we cannot get to know them. So law reporting is important, and that will lead to have what we call like those decided cases. And then two, the principle of established position or principles of law in the cases. The hierarchy of courts is very important. Hierarchy of courts is important. So precedent also require the court structure. In the court structure, we know that the Supreme Court decision is binding on all courts in Ghana. And even generally, the Supreme Court is also bound by its own decision, except that it can make a departure from it where it deems it appropriate so to do, as we saw in Article 129 of the Constitution. I think to be quite specific, I think is the Article 129 clause 3, right? If you look at the Article 129 clause 3, which says, quote, the Supreme Court may, okay, maybe you can even start from the, we start from clause 2. The Supreme Court shall not be bound to no decision of any other court. Okay. So in terms of decision of the Court of Appeal, High Court, is not binding on the Supreme Court. But let me say, in practice, where the Supreme Court does not have on a particular principle of law, and if it is the High Court which has decided that principle of law, the Supreme Court may find it and give its imprimatur or its approval to it. So that is one thing to know. And if you look at the 129 clause 3, that the Supreme Court may, while treating previous decision as normally binding, depart from a previous decision when it is right to do so. And all other courts are bound to follow the decisions of the Supreme Court on questions of law. Good. So the meaning of that, in the first place, the Supreme Court must follow its own previous decision. On the other hand, the Supreme Court can decide to depart, follow its previous decision on the matter, where the Supreme Court is convinced that its previous decision on a particular matter or point of law is not advancing the cause of what justice and so on and so forth, then it may make a departure. And then the third point is that all courts in Ghana are bound to follow the decision of the Supreme Court on questions of law. Whether they agree with the Supreme Court or they don't agree with the Supreme Court, it is mandatory. So that is one thing that we should note. Good. So we have known that Like to have a judicial precedent, you must have like the a law reporting system to make decided cases available. You must have like the court structure so that you know which courts are able to lay down binding decisions and so on and so forth. Another thing to note is that judicial precedent must be consistent with the general principle which lies at the root of the legal system. And those general principles simply the fact that a common law tradition, and the common law tradition, we follow a structured approach to some courts are more senior than others, and so on and so forth. So maybe we, if we don't have the luxury of time, but otherwise you have asked you to contribute to what is judicial precedent, and then what is judicial precedent? Anybody? I have 4 questions, so I want 4 students. So question 1, I need 1 student to, if you are ready to speak to question 1, just raise up your hand, then I'll allow you. And when I allow you, have just 30 seconds just to give your response. Question 1, what is judicial precedent? Yes, anybody? Oh, you don't want to be interactive? If you don't want to be interactive, then the lecture without you, as I did in the afternoon, and then I'll just send it to you so that we can play it. But if you are going to have a live session, then you have to be interactive. So if you are not talking, then I'll not have a live class with you. I just do my recording and send it to you. Okay, so we have Ella. So 1. Yes.
Okay, look, judicial precedent is basically about a decision of a court on. It's okay. It talks about the fact that matters of decision of a court on matters of law, it's binding on the lower courts in relation to principles of law.
Okay, I mean, that is fine. Ella, thank you. So we are done with question 1. Question 2, distinguish between judicial precedent and res judicata. Who will take that for us? Ella has answered question 1, so let's take question. Okay, I've seen McDonald, Nano's hand up. McDonald.
Yes, good evening, Doc. Good evening. Okay, so please, based on what you just told us some few seconds, you're making us understand that when we talk about res judicata, we are saying that it's a matter that has already been dealt with and should not be attempted at anymore. Once it's done, it's done. And then when we come to judicial precedence, we are saying that at the end of the day, there are decisions that have been taken, and these decisions become binding on lower courts. You have just made us understand that the decisions of the Supreme Court are binding by itself. And then there are instances where the Supreme Court can decide to depart from the previous decisions that it has taken.
Okay, yeah, that is true. Thank you very much.
Hello.
Yes, thank you, McDonald.
Yes, sir.
Okay, so let's come to question 3. We need somebody to answer question 3. McDonald has answered question 2. What things must be present for judicial precedent? Any volunteer? Quick. We have a very limited time. I have a few minutes to end this class so that I can drive home. Yes. And we have yes. Ella again. We have yes. Yeah. Bex. Bex. Question 3.
Okay. Good evening, Doc. For question 3, I think we need a good system of law reporting, and then we need good cost structure. There must be the cost structure in place, and then we must have a list of decided cases to look on. Yeah.
Bex. Now, the fourth question, we need someone to answer. Fourth question. Describe the hierarchy of courts in Ghana. Bex has already answered the third question. So who will take question 4 for us? Yeah, Kofi Blankson. Yeah, Kofi Blankson, please.
Hello.
Go ahead.
The hierarchy of courts in Ghana. Article 126 of the 1992 Constitution describes the courts in Ghana. And per 126, we have the court have been classified into two. That is the Superior Court of Judicature and the lower courts. And under the Superior Court of Judicature, we have the Supreme Court at the apex, the Court of Appeal, the High Court, and the High Court or Regional Tribunal. Then the B says that the Parliament shall decide the court that will fall under the superior, what do you call the lower courts. Thank you.
Okay, so Kofi Blankson. Okay, let somebody help. Yes. Who is H? Somebody call H. Yeah. Yes, H. Yeah. Yes.
Okay. Hello, sir. Yes. And then the lower courts as well, from Act 459, which is the Courts Act.
Then you
consists of.
what are they? What are the lower courts?
Okay.
What are the lower courts?
We have the district courts, we have the circuit courts, and then we have, I think, the forgotten the last name.
Okay, all right. Thank you very much, all of you. But another thing we should add, if you look at Article 126, which Blankson quoted, 126, Clause 1, Paragraph B, that such lower courts or tribunals as Parliament may by law establish. So apart from the traditional courts, the circuit court and district court, we have other tribunals, and they are all lower courts, so to speak. Unless where maybe it's a lower court, but then the court, the law has said that its decision may have maybe the effect of like a high court and things like that. Maybe like the judge, and so on. More or less, they play adjudicating role, isn't it? And in some respects, the Labor Commission, and then we take the disciplinary committees for the various professional bodies, medical and dental council, nurses or midwifery council, legal council, and so on and so forth. So just for your information. Okay, thank you very much for the contribution. So what part of a case is binding for purposes of precedence? What is it that binds the lower courts in the hierarchy? Of course, we know that Article 129, Clause 3, decision of the Supreme Court is binding on all courts. That is fine. And in that order, decision of the Court of Appeal is binding on all courts, including the Court of Appeal. And the Court of Appeal does not have the power to depart from its precedent. So when it comes, the Court of Appeal is bound by its precedent, like the High Court is bound by the decision of the Court of Appeal. And of course, the High Court also is bound by its precedents as well. And all the courts below that order. But fundamental question is that what is it about the previous case, the precedent, which is binding? And that is why it's important for us to distinguish between what we call obiter dictum and ratio decedenda, because it is a principle of law, the proposition of law, the statement of law, or what they call the holding in the case that is binding. That is the statement of the law, principle of law, which is binding. And so that is like the ratio dissidenda. Now, ratio dissidenda literally means the reason or ground for the decision. And it is any rule of law expressly or impliedly treated by the judge as a necessary step in reaching his conclusion, having regard to the line of reasoning adopted by him or necessary part of his direction to the jury. So that is the ratio dissidenda. In other words, the material facts, the essential facts of the case, stripped of all the unnecessary decorations and so on, would raise a question, and how the court will answer that question, that statement of law, which the court will count in the light of the material facts in that case, is what will be called like the ratio dissidenda. So that principle of law within the context of the material facts as established, that will be the rule which governs the decision in the case. And it is that which will count as a binding precedent. So that is very important. And a number of cases, draft farms, the Court of Appeal made the point that ratio dissidenda is the only principle or reason a decision which necessarily supports the conclusion. But the other thing that we see about ratio dissidenda is that the ratio dissidenda of a case, let's say decided today, may not sometimes even be obvious, and future courts, or when that case is heard before other courts in the future, then the court will have to work out what the ratio dissidenda of this particular case, which are decided before them, was. When that has been determined, before the court can go ahead and say that it is binding on us and relevant to this case or not, as it were. And obiter dicta, when it is plenty, we say obiter dicta simply means other things which were said, or important statement of law which was said, but which was not relevant to the issues before the court, relevant to the material facts. A court is confined to deal with the issues in controversy and the facts, giving rise to that issues in controversy. So in the course of doing that, the judge may, for example, create analogy or make some other commentary. Now, those commentary, for example, may be a succinct, principle of law, though not really relevant to the issues in controversy. And depending upon the standing of the judge, whether he's a very respectable judge, knowledgeable judge, and so on and so forth, his statements or cite comments, or by the way, comment not relevant to issues in what you call like the obiter dictum or obiter dicta, may be cited as being of persuasive effect in future cases, but it is never precedent. So that is one thing that we should pay attention to. Yeah, so as I indicated, the obiter dicta does not bind any future court, and it may only provide the assistance. So we could say that obiter dicta is of two kinds. First, we have a statement of law based on facts, which either were not found to exist or found to exist, were not found to be material. In other words, the court could have said certain things that if this had been present in this case, then the position of the law would have been that. So what that means is that the court did not find certain facts present, and for that matter, what it said the position of the law would have been is not really relevant to the case. And that will be obiter dictum, as it were. On the other hand, the court may also make statements which are based on the facts as found, and yet the court may create some distinction and say that that principle does not actually apply in resolving the issue due to XYZ, and that will still be obiter dictum, as it were. So if you, the number of authorities in this regard, Bank of Ghana, and then you look at the Harley case. If you look at my work at the page 146, you get so many things on this. I'm talking about like this particular book, just in case you are not familiar with it, as it were. Okay. So what are some of the advantages of the DECISIS? We know it ensures certainty and predictability in the judicial system, and predictability is very important, especially. And it is also, it resonates well with the doctrine of the concept of rule of law, because rule of law is against arbitrariness, isn't it? And judicial precedent ensures certainty, and for that matter, predictability in the judicial system. And again, it promotes fairness and efficient adjudication of disputes. So that if you have a particular set of facts and same set of facts have come before the court and a certain conclusion in terms of like the principle of law was laid down, you could be very certain that the courts are likely to apply the same principle. And for that matter, these are likely to be the consequences. And then it promotes uniformity and public confidence in the judicial system. Yeah, and it flows from the fact that there's a consistency, isn't it? Consistency. If similar facts occur, then what was done before would definitely be done. So long as no distinction has been established, no distinguishing has been done, as it were. And again, it provides a reason foundation for judgments. Judicial precedent enables judges to account for why they came to certain decision. I've come to this conclusion because in a similar case, XYZ, that was how it was resolved, and it's just like what I have. Or this case before me is somewhat different from the similar case which happened. That is why I have come to a different conclusion. We're able to provide a reason foundation or justification for making judgments. Yeah, so, and again, it goes without saying that judicial precedence or DECISIS, as a judges and judicial making, decision making, you don't need to reinvent the wheel, isn't it? Sometimes there may be a very complex problem, and you are thinking of how do I go about it. Thankfully, you go to the law reports, similar complex problems came and they've been resolved. So just go and look at how it was resolved, and then if you are convinced that the material facts are the same as the material facts before, then you apply it. So you don't reinvent the wheel, as it were. Let's look at then the downside, that is the demerits or the disadvantages. An argument will be made that judicial precedent hinders flexibility and adaptability of the law. And particularly so, if you take courts other than the Supreme Court, because we've seen that per Article 129, right? Article 129 clause 3 of the Constitution, decisions of the Supreme Court is binding upon all courts in Ghana on points of law, whether you agree, you don't agree, whether it's a good decision or it's not a good decision, you're bound by it. So that is another problem. That is another problem. And again, sometimes, because of the binding nature of certain precedents, the court cannot even be creative, regardless of the case before them and how novel it may even be. And for that matter, bad decision can stand for a very long time. If you take, let's say, the Supreme Court, for example, Supreme Court is a human institution. They are not infallible. Even His Holiness, the Pope, his infallibility only applies to statement of faith when he is speaking ex cathedra, when he's speaking his official capacity as Pope, guided by the Holy Spirit. Then Catholics will say that in terms of statement of what the Christian faith is, he doesn't make a mistake, but he's guided by the Holy Spirit. I mean, that is different. When it comes to judges, they are not using any spiritual things. They are using the normal reasons that you and I use. They are not perfect. They can make mistakes, and they do make mistakes. So if there are bad decisions, then it's going to be around us for a very long time, isn't it? Yeah, so that is one thing that we have to note. And then another demerit is that ratio decidendi may be difficult to establish and also distinguish. Before you can say that this precedent is applicable, binding, and all that, you need to practice the ratio decidendi, principle of law established according to the material facts of that case. You need to establish that and say that if we read this judgment, these were the essential facts, and within the context of these essential facts, the court propounded this principle. Now that is crucial, and that is what will give you the ratio decidendi. And working it sometimes is difficult. And again, you may get, if you like, the two competing precedents. You need to be able to establish the ratio decidendi before you can say that, okay, on this same point, okay, although they seem to be similar, but the ratio decidendi here is different from this and all that, then it's not very easy to do that. So that is another difficulty. Again, another demerit is that judicial precedent overemphasize, of course, and sometimes individual judges. Of course, that is obvious. And then the material facts in the present case are hardly the same on all fours as previous cases. It is not true that the assumption, right, which underpins the operation of judicial precedent, is that straightforward. And that assumption is that the material facts of the present case should be essentially similar to the material facts of the case whose decision, whose ratio decidendi is being edged on the court as applicable and binding to the current case. The material facts may not be on all fours. There may be some minute distinction here and there. So these are some of the things that we have to keep in mind. But we need to know that the doctrine of stare decisis is not absolute. That is to say that, yes, it is not an inflexible rule. It's not an inflexible rule in the sense that there are ways by which you can circumvent it, by which we can choose not to follow it. What are some of these ways, or what do you call like the exceptions? For example, one, where a trial court can distinguish the superior court decision. So distinguishing, right? Distinguishing of a precedent simply means that a court for which a precedent has been cited is trying to say that the precedent which have been cited as being binding and all that, in terms of the material facts, are not necessarily similar to the case before it. And for that matter, despite the fact that that decision is, let's say, a decision of the Supreme Court or decision of a more higher court, and by the hierarchy of courts and all that, it is ordinary binding. The trial court or the particular court is trying to go and demonstrate that it is distinguishable, so it's not applicable as it were. So if you can show that, if you can show some differentiation in terms of the material facts of the case before you and the material facts of particular precedent, if you can show that there is some important distinction, then if they are not the same, the elementary foundation for operation of precedent will be met. And for that matter, despite the fact that it's a decision of the Supreme Court or Court of Appeal or even High Court, you are in the circuit court, you can distinguish it and not follow it as it were. So that is the kind of exception that we are talking about. Yeah, so a case is said to have been distinguished when the judge states that the material facts are sufficiently different to the case before it. So therefore, different rules of law will have to be applied and not that precedent. Then another exception, another way of circumventing binding precedent, going around binding precedent, is where the precedent can be demonstrated per incuriam. So per incuriam simply means a want of care or lack of care. That is to say that the decision was given wrongly in the sense that there is a particular law which is relevant, which was, for example, not taken into account. But let me also quote what Black law says on the per incuriam, page 1254 of the 9th edition. Black's law speaking, quote, per incuriam of judicial decision means wrongly decided, usually because the judge or judges were ill-informed about applicable law. Then he will cite Lewis Philip P. Jones' work, Drafting Interpreting Legislation. This is what they say, quote, there is at least one exception to the rule of DECISIS. I refer to judgments rendered per incuriam. A judgment per incuriam is one which has been rendered inadvertently. Two examples come to mind. First, where the judge has forgotten to take account of a previous decision to which the doctrine of stare decisis applies. For all the care with which attorneys and judges may comb the case law, errara humanum est. That is what? Human. And sometimes a judgment which clarifies is somehow not indexed and is forgotten. In such a case, it is in cases such as this that the judgment rendered in contradiction to a previous judgment that shall be considered binding, and in ignorance of that judgment with no mention of it, must be deemed rendered per incuriam. Thus, it has no authority. The same applies to judgments rendered in ignorance of legislation, of which they should have taken account. For judgment to be deemed per incuriam, that judgment must show that the legislation was not invoked. And Rupert Cross will also add his explanation. As a general rule, the only cases in which decisions should be held to have been given per incuriam are those of decision given in ignorance or forgetfulness of some inconsistent statutory provision or authority binding on the court concerned, so that in such cases, some features of the decision or some step in the reasoning on which it is based is found on that account to be demonstrably wrong. Good. So we know what the per incuriam is. A decision was given which would have been precedent, but for the fact that it was given erroneously, in what respect? There was, let's say, a legislation. There was a legislation, a statutory provision, which was relevant. The court might have ignored or might have forgotten and did not have a regard to that. And for that, the lower court can demonstrate that despite the decision of the Supreme Court, or this is a decision of the Court of Appeal, there's this provision of this Act of Parliament or so on, which was ignored. And for that matter, that decision is per incuriam, and we don't consider it as binding on us. Or let's say that the Court of Appeal has given a decision, and that decision, for example, ignored a certain relevant decision by the Supreme Court to an aspect of the case that decided. Then let's say the High Court or any other court applying the Court of Appeal decision to say that it was given per incuriam as it were. Yeah, so you can look at the case of Botry and Edway. And then Edwards and the Diners Club Swiss. So the point to note then is that a decision will not be binding if it has been overruled by a higher court, right? Maybe if a decision of the Court of Appeal has been overruled by the Court of Appeal, then even a district court can ignore it. Or if it has been overruled, if it has been overruled by by a statute, then that can be that is not a binding. That or if it was made, it's also not binding, as we have just said. Okay, so we've also made the point that we need to have like the doctrine. We need to have like the hierarchy of court or the court structure in trying to discuss the operation of the stare decisis, and Chapter 5 of the Constitution and the Courts Act, as all the discussion done on the court structure are applicable as it were. So let's keep that in mind. Okay, let me get one or two people to address this question. With the aid of relevant provisions from the 1992 Constitution of Ghana, describe the operation of judicial under the Ghanaian court system. One lady and then one gentleman. Just hurry up so that we can start our criminal law some 30 minutes and then I can go. Yes. One lady and one gentleman. Okay, we have a gentleman. McDonald, okay. And then which lady is coming? Yes. McDonald, yes.
Yeah, hello. Good evening, Doc, once again. So, Doc, like you were asking, the question is asking us to, or is inviting us to look at the hierarchy of the courts in Ghana. Would say that we want to apply the Constitution, the 1992 Constitution, the Article 25. That gives you the court structure. We are saying that when we look at the court structure, we can divide it into two, i.e., the Superior Court and then the lower court, if you like. When you come to the Superior Court, we are talking about the Supreme Court, we're talking about the Court of Appeal, and then High Court. Then when you come to the lower court, you want to deal with the Circuit Court, you want to deal with the District Court and other, or the regional tribunals or the juvenile court, if you like. Doc, you have told us earlier that the decisions of a superior court are binding on of the lower court. So when we take of the Supreme Court, for instance, we're saying that it binds on all other courts, be it the Court of Appeal, the High Court, the District Court, Circuit Court, and what have you. And then we also want to say that there are instances where the Supreme Court can depart from its decisions when it finds it so necessary to. So we are saying that there are certain things that we want to look at in terms of jurisdiction. Well, the Supreme Court has it has an appellate jurisdiction. It also has an inherent jurisdiction when it comes to issues with regards to the constitutional interpretation and also hearing also saying that the Court of Appeal would also hear appeals that emanate from the High Court and then the lower courts. Where when it comes to criminal courts that come in from the Circuit Court, it can go to the Court of Appeal to be heard. Doc, we want to say that the High Court has an inherent jurisdiction in terms of human rights issues. Again, when we want to talk about the money aspect, monetary issues, we are saying that with regards to the District Court, we know that it's dealing with 500,000 Ghana cedis, and then which that is the cap. So apart from that, this is the little I can say for now, though.
Okay, all right. Thank you, McDonald. Let's take the lady. Yes. The lady. Any lady? We don't have ladies with us tonight. Any lady to add to that? Okay, maybe I've seen a lady's name, so let me invite one. Okay, Bex, but as I'm going to call her Adjoake. Okay. Yes, Bex.
Okay, Doc. I think I would start by explaining what judicial precedent is and the things that are needed to be able to practice an efficient judicial precedent. And then I'll move on to talk about each of them. The fact that I don't know if the Constitution has a provision that enables us to record our do law reporting, but I know I don't know if it's a statute or it's in the Constitution. I think I'll need to find out. So I'll talk about that provision that allows law reporting, and then I'll talk about the court structure, the fact that we have a court structure in place, and the fact that we have previously decided cases, and then per article, I think 129. The fact that the Supreme Court is supposed to be bound by its decisions, the fact that the Court of Appeal is also to be bound by its decisions as well as lower courts, and the fact that the High Court is also bound by its decision. And I think I'll also go on to talk about cases where we can be able to not apply judicial precedent, where there's the decision of a case per curiam, and also the fact that other high courts are not to be bound by the decisions of their of like other high courts as well. Yeah, I think that's all I can say.
Yeah, so I think that you look at your constitution and you ask yourself, and of course you provided the answer already. So thanks, Bex. Decision of the Supreme Court binding on all other courts down the hierarchy of the courts. Yes, the answer is yes. And the authority is what? 129 clause 3. Can the Supreme Court depart from its own previous decision? answer is yes. And again, Article 129 clause 3. If yes, under what circumstance? What the Constitution say, 1293 is that when it appears to it right to do so, right? So the circumstance is that when the Supreme Court consider that it is right or appropriate for that to be done, then it will do that. And two, a decision of the Court of Appeal binding on no other lower courts down the hierarchy of the courts. Yes, the answer will be yes. If you look at the Constitution, you get that. Is the Court of Appeal bound by its own previous decision? Yes, the answer is yes. And if you look at the Constitution again, the Court of Appeal is definitely bound by its own previous decision, especially Article 136, clause 5 of the Constitution that subject to clause 3, 129 of this Constitution, the Court of Appeal shall be bound by its own previous decisions, and all of other than the Court of Appeal shall follow the decision of the Court of Appeal on questions of law. Okay, so 136 clause 5 it says that, and then are decisions of one high court binding on another high court. A decision of one high court binding on another high court. Yes, if a high court has decided a matter, it doesn't matter that, because we have only one high court. So there's nothing like this high court is the same as mine, but that matter is not binding on me. It's binding, except where you can use the principles of distinguishing to show that it's not applicable, otherwise it's binding. Are lower courts bound by decision of the superior court? Yes, the answer is yes. Yes, Eben.
Hello, sir.
Yes.
Hello, sir. Please, can you hear me?
Yes, I can hear you.
Sir, please, where there's the slide that you have the question on, with the aid of relevant provision, the question that my colleagues just attempted.
Yes.
You stated that in attempting that question, you must refer to the Constitution, particularly chapter 25. I want clarification. My Constitution, what I have here, the chapter 25 talks about amendment of the Constitution. And so.
Oh, no, sorry. Thank you very much. Thank you. It's an error. I mean, Article 125, okay. That, or chapter 11.
Okay.
Yeah, thank you very much, Eben, for bringing that. That is obviously, oh, you are right. It's not chapter 25, it's Article 125 of the Constitution, and it's related with the provisions, or chapter 11 of the Constitution. Thank you, Eben. Okay, so we will use a few minutes to start the criminal law revision that I promised, and I'm going to use material we used last year. The last year, around the COVID era, we're doing this. Those of you who attempted last year and have still not passed, you can testify to that. But my prayer is that this will be your last one, and then you get this through. Let's say a big aiming in your own heart. That it will happen, and keep working towards that. Okay, so we come back to, as I said, the criminal law, and you want to spend, it's now 9:51. I will spend some few minutes with you, and then I'll close the class. So all the following are involuntary agent, except A, animal, B, car, C, 10-year-old, D, a pregnant woman. So again, if you take your criminal offenses Act 29, especially if you look at the section 13 to section 26 and 52, I think that we can get a very useful idea regarding what the question is testing. So for example, let's go to section 13.2 of the Criminal Offences Act 29. So if you look at 13.2, for example, it defines what we mean by involuntary agent. So 13.2 will say that, I quote, for the purposes of subsection 1. So let's even start from the 13.1. A person who intentionally causes an involuntary agent to cause an event shall be deemed to have caused the event. So some persons are considered as involuntary agents. Now, if you cause an involuntary agent to do something, now that involuntary agent is not going to be fixed with criminal liability. The person who caused the involuntary agent to do that will have to be fixed. So let's look at who the involuntary agents are then. So if we look at section 13, subsection 2, quote, for the purposes of subsection 1, involuntary agent means an animal or any other thing, and also a person who is exempted from liability to punishment for causing the event by reason of infancy or insanity or otherwise under a provision of this act. So we have been given the range of those who are considered what? Involuntary agents. Animal or a thing, inanimate thing. So animal or inanimate thing is an involuntary thing. And then when it comes to human beings, some human beings are also treated as involuntary agents and exempted from criminal liability. Who are those? Infants. And then when we say like the infants, we have to be careful. We are not referring to the infant that we know in law of contract or like the Companies Act or the Constitution or the Children's Act. Infant is explained in section 26, right? Section 26 of Act 29, as it says, I quote, for the purposes of the criminal law, a person under 12 years of age is incapable of committing a criminal offense. And that is what we call like the dolus at an incapacity or incapacity dolus. So if you look at the, so the person by reason of being below the age of 12 is considered by the law as being incapable of committing a crime. So we should take note of that. And as I indicated, there's a Latinate way of putting it, the dolus incapacus, as it were, or some would say doli incapacus, right? Doli incapacus. That is incapable of wrong, is a Roman law concept. And that is what we have captured under section 26. So if you are incapacus doli or doli incapacus, it simply means that you are incapable of committing a crime. And within the context of our Criminal Offences Act, particularly section 26, if you are below the age of 12 years, you are incapacus doli or dola incapacus, they are all correct, meaning that you are considered as incapable of committing criminal offense. Good. Again, if you look at the section 13.2, apart from who are exempted from criminal liability on the ground of their dolus incapacus, we also have insane persons, those who suffer from insanity, right? So those who suffer from insanity are also considered as being incapable of or are those, they cannot bear criminal liability as it were. Not only them, because if we look at the provision, it says that, or otherwise, okay? So there are some other instances in which a person may be exempted from criminal liability as it were. And another good example is, for example, if you take maybe like let's take like the section 52 D, right? That a person who intentionally causes death for another person by unlawful harm, commits manslaughter and non-murder or attempted murder. If that person, of course, is not exempting them from criminal liability, but is only trying to extenuate or trying to mitigate or downgrade the criminal liability. You've killed someone, but we are not going to hold you liable for murder by reason of, let's say, D, being a woman, she caused the death of a child, which is a child under the age of 12 months at the time when the balance of a mind was disturbed because she had not fully recovered from the effect of a giving birth to the child, or by reason of effect of lactation consequent on the birth of the child. Yeah, so when we have like the post birth or delivery kind of condition, the law can give you some margin of exemption, and that is why even if you kill, let's say, like the child below the age of 12 months and all that, we will not be charged with like murder, but the manslaughter, as it were. So let's come back to our question. All the following are involuntary agent, except what is the answer to one? I'm giving you enough hints. We'll discuss enough things. Help us to get the answer. So let me look at what you said. Okay, D. And Elikem has Elikem. Can you, yeah, the good pregnant woman. Elikem, can you tell us about the Aaron Sanders, the case that you mentioned? Elikem, where is he? Elikem, put up your hands so that I will release you. Where is Elikem? Elikem, raise up your hands so that I will ask you to unmute. You put an authority in the chat, and I would like you to share with us. That's why I'm asking you. Is Elikem there? Aaron Sanders. Where is? Okay, anyway, he doesn't want to talk. That is fine. Okay. Okay, Nyamiche. Okay, Nyamiche. Nyamiche, yes.
Hello, Doc.
Hello.
Hello.
Yes, Nyamiche, go
Good
ahead.
evening, Doc. Thank you for the opportunity.
Good.
Yes, our versus Saunders, I think, is to the effect that the man wanted to poison the wife through an apple. The wife took a bite and then gave the rest to the child.
Okay.
The child eventually ate it and passed off.
Right. Right. And what happened? Okay, thank you. I think your friend Freduah too would like to help. Thank you, Nyamiche. Freduah. Freduah. Freduah, please. Yes, I've asked you to Freduah. Okay, I think she's not paying attention. So let's say Jacob. Jacob, yeah, you can unmute yourself.
I think hello, Doc. Good evening.
Good evening.
I think that authority is not related to our question. I think that authority is about transfer malice.
Transfer malice. Okay. Okay. So once you've mentioned it, can you explain the doctrine of transfer malice? Yes. I believe we're doing a revision, so if anything comes up, we take advantage to clarify. So Jacob, explain the doctrine of transfer malice. Jacob. Jacob, are you there? Hello, Jacob.
Hello, Doc.
Yes.
Hello.
I want you to explain the doctrine of transfer malice. Oh, it keeps. Jacob, you've muted. Yes. Jacob, are you there? Okay, Namiche would like to come back. Yeah, Namiche, go ahead. Namiche, I've released you.
Hello, Doc.
Yeah, Jacob.
Hello.
Yes, please go ahead. Jacob, go ahead. I can hear you. Jacob, okay, Jacob is having challenges. Yeah, Barrister, you haven't spoken to Anthony.
Yeah, so I'd like to talk on the doctrine of transfer malice once the person is not available again. Okay. So I think it is the doctrine for establishing consent or intention when it comes to causation in the criminal liability. So it is to the effect that where a person A maybe intend to cause harm or some kind of like that to a person B, but it misses that person, and then the harm actually resulted in targeting a different person. So the law says that it imputes an intention or the transfer, that the intention to cause harm to the original party B will be transferred to C, so that A will be held liable to have caused the harm of C as if he had intended to cause harm to that person. And this is found under section 11(6) of the Act. And then it was held in the case of Ametewi against the state, where someone who aimed at assassinating the then president missed him and then killed the bodyguard. So the court decided that the intention to kill the president will be transferred to the intention to cause the bodyguard, and the person will still be liable in that respect.
All right. Okay. All right. Thank you. Thank you very much. So, okay, I think Jacob, no, I think the first speaking, Tony is gone. Okay, so let's lower your hand. Thank you, Barrister. Okay. So, yeah, consent for purposes of criminal act or criminal intent. And I would like you to know the 7 points in section 14, right? You have to know how consent is understood for purposes of criminal liability. And it's not difficult. Just read section 14 and make sure that you are familiar with all the senses in which consent has been explained. So if you take 14, that where it is required for criminal acts or criminal intent that an act should be done or intended to be done without a person's consent, or where it is required for a matter of justification or exemption that an act should be done with a person's consent. The following rules or principles are essential. So we have to know all of them, especially for purposes of your multiple choice, or sometimes even if you have like a problem-based question and you are discussing maybe defenses or something like that. So A, consent is void if the person giving the consent is under 12 years of age. Yes, so the dolus incapaz also means that if it's not only that the person is incapable of committing the crime, the person also lacks capacity to give consent. And for that matter, if, let's say that you've done something with or against somebody below the age of 12, don't say that the person consented. No, that does not apply. Or in the case of an act involving a sexual offense, 16 years. So if you have sex with somebody 16 years or below, it doesn't matter that the person consented. You are still guilty of defilement. And that is why we see that in the case of rape, 18 years and all that, if the person consented, then that is a defense. Or it's by reason of insanity or of immaturity, or of any other permanent or temporal incapability, whether from intoxication or any other cause, unable to understand the nature or consequences of the act to which the consent is given. Then the consent is what is void. So we have to be familiar with this so that when we are tricked for purposes of like the MCQ or the multiple choice question, we will be able to work our way. And then 14b, consent is void if it is obtained by means of deceit or duress. And deceit here, we go back to Derry and Pick, Lord Herschel, because it's the same as like the fraud. If you give your consent as a result of having been victim of like a fraud and so on and so forth, then that consent is void. Or duress, intimidation, and all that. Or C, consent is void if it is obtained by or under the exercise of an official, a parental, or any other authority. Maybe like, let me say something. Let's say for sexual offenses, okay? Let's suppose that you put a substance in a drink for a woman to drink, and then you had like the sexual, like you had sex with the person, and you don't say that the person consented, because you have to know that the seeming consent was vitiated because she was not in charge of her own mind because of what you put in the substance. So let's keep that in mind. Or C, consent is void if it is obtained by or under the exercise of an official, parental, or any other authority, and the authority which is exercised otherwise than in good faith for the purpose for which it is allowed by law is for purpose of this session a power unduly exercised. So consent, if for example someone is in a public official or has a certain power and he used it somehow to blackmail you, right? So as to get you to consent to something, that consent is still vitiated for purposes of criminal liability. It's not a valid consent. Then D, a consent given on behalf of a person by the parent, guardian of that person or any other person authorized by law to give or refuse consent on behalf of that person is void if it is not given in good faith for the benefit of the person on whose behalf it is given. So if you were entitled to give consent on behalf of a person, let's say that you stand in loco parentis, right? You stand in loco parentis, you're a guardian for a ward or a child, and the law says that you can give a consent for the person if, for example, give a consent for something which is inimical to the welfare and the interest of the person that you stand in loco parentis to, then the court will say that that consent is not a valid consent. And if it's in relation to a particular crime, you will be deemed to have actually been guilty if other things are satisfied. Consent does not have effect if it is given by reason of a fundamental mistake of fact. So pay attention, not mistake of law, right? And I think remember the case of the R and the Nyameneba. Who can tell us about that, if you remember? Nyameneba. Okay. Ni, and then Freduah.
Yeah.
Yeah, Doc.
Yes, how are you?
Good evening, Doc.
Good evening.
Yeah. Nyaminibe's case was they were using some herbs that they say is from their forefathers and herb of life. And they were using it without knowing that it is marijuana. So within them, they don't know it is marijuana and they don't know that it's a narcotic that must not be used. So they were using it like something that like contumely or like any other leaf that they think will help them.
Right.
So they made a mistake in the facts. That is why it is a defense.
Right. Right. Okay. Right. Thank you. Yeah. So if you give a consent as a result of a fundamental mistake of fact, then the position of the law is that that consent is not does not have effect. And F, a consent is for purpose of this session obtained by means of deceit or duress or of the undue exercise of authority, or to have been given by reason of mistake. If it will have been refused, but for the deceit, duress, exercise of authority or mistake. And so just giving us a more explanation as to when we can say that a consent was not properly extracted, and for that matter, it's not binding. Then G, exercise of authority for purpose of this session is not limited to the exercise of authority by way of command, but includes influence or advice reporting to be used or given by an authority. So telling us that when we say like the authority is quite broad as it were. I've seen like one stubborn cockroach just fly somewhere in my office and it's quite strange. That's why I'm distracted. Just a second. Okay, then H. A person shall not be prejudiced by the invalidity of a consent if that person did not know and could not by reason of reasonable diligence have known of the invalidity. Yeah, so please just be familiar with all this as far as consent is concerned, for criminal law is concerned, because in your examination, they could say that for purposes of like the criminal intent, the following are not true as far as consent is concerned. And then the person will repeat most of this and then we'll put in one which is completely unrelated. And then it will be your duty to actually tell us the correct answer as it were. I've seen Hoodie's hand up. Hoodie, is it up now or in relation to the previous question? Hoodie, your hand is up, unmute yourself.
Yeah, it was in relation to the
question. No problem. No problem. All right, thank you. So let's take
particularly the question relating to.
Okay, no problem. Okay, so let's take another question before we get ready to go. In terms of the Criminal Offences Act, 1960, Act 29, what is the effect of mistake? What is the effect of mistake? Yeah, so we have to look at section 29, right? You have to look at section 29 of the Criminal Offences Act, which was about ignorance or mistake of fact or law. And the provision is that subsection 1, quote, a person shall not be punished for an act which by reason of ignorance, mistake of fact in good faith, that person believes to be lawful. 2, a person shall not, except as in this act, otherwise expressly provided, be exempt from liability to punishment for an act on the grounds of ignorance that the act is prohibited by law. Good. So section 29 has told us about how mistake operates in relation to facts and then in relation to law. And we look at the case of the Amended against the states. And you have to know that ignorance of the law is what? Is no excuse or defense. So ignorantia juris non excusat. So therefore, we have the following options. It is no defense to, let me look at your answer. Okay, Solomon Aaron Tosin, Foley and the Republic. Foley, okay. Okay, it's a complete defense to a criminal charge. It's a partial defense to a criminal charge. It reduces the offense charge to a lesser one. No, I think what we read, section 29, is quite obvious. That a person shall not be charged for an act which by reason of ignorance or mistake of fact in good faith the person believes to be lawful, meaning that it is complete defense, isn't it? It is an absolute defense to a criminal charge, as it were. But I would like some of you who provided the authorities to speak to them. So Joshua, tell us about Aaron Tolson, and then Freduah, tell us about Foley the 8th against the Republic, okay? So raise up your hand and then let me release. So quick. After this, we'll do one more question, then we finish the class for tonight. I need to go home. Yes. Okay, Freduah, so tell us about Foley the 2nd. I mean the 8th against the Freduah, go ahead.
Okay, so Doc, Foley the 8th had to do with the community. Someone died, and then they said that person had not been engaging or had not been had not been taking part in communal labor. So when he died, they rather cremated the body without lawful authority. So they said they were not going to bury him. And when it was taken to court, the court said that their plea was on ignorance of the law. And the court held that a person could be guilty of conspiracy to commit a statutory offense in spite of his ignorance of the existence of that particular statute. So the fact that the appellants or those who committed that particular offense did not know of the existence of that particular law. There was a law in force which spoke against the cremation of a dead body. So the fact that the appellants did not know of the existence of that particular law was a criminal offense, and that it amounted to no defense.
All right. Thank you very much, Foley. Now let's take, Freduah. Now let's take Joshua. Joshua, tell us about Aaron Tolson. Joshua, put up your hand. Joshua is not there. Okay, so then let's allow Ella. Okay, Joshua has come. Yeah, Joshua. Joshua, mute yourself. Yeah, Joshua, go ahead.
Please, can you hear me?
Yes.
Okay, please, the case of versus
in it concerned a woman who was married to her husband. She said that so she pleaded back, and then the
Joshua's relation is not good, so it's affecting the sound quality. So they couldn't hear everything. Okay, but at least you all know, Aaron Thompson. Now, our last question for tonight: which type of crime will be classified as a straight liability crime? Remember that the basic elements for constitution of a crime or criminal offense is that in criminal law theory, you must have actus reus, you must have the mens rea. So the actus reus is the particular conduct or omission which is prohibited, or which the law prohibits. The law does not want to happen. That is the act or the omission. And then the mens rea is the requisite mental state, the guilty mind required before one could be said to have committed the crime. So you must have the coincidence, you must have the coming together of the mens rea and the actus reus in order to have a crime as constituted. That is the traditional theory of criminal law. But we also have what we call the straight liability offenses. And for straight liability offenses, we do not require a distinct mens rea. And it's usually the prohibited act, because the prohibited acts, one is committed, it is implied that the mens rea is embedded in the prohibited act. So therefore, what type of crime will be classified as a straight liability crime? A, one with mens rea and actus reus, certainly not, because we've explained what it is. B, one with mens rea without actus reus, certainly not. If you have only the guilty mind and you haven't done the act, that is no crime. If you are thinking of blowing up a building or a plane, and you haven't done that, it's just in your mind, that is no crime. Of course, that is, if you are thinking of raping someone and you haven't moved and it's just in your head, that is no crime. Yeah. So B will not apply. C, one with actus reus without mens rea. Yes, that is it. And D, one which is regulatory in nature. Not necessarily, because some offenses which emanate from like the Bureau's regulation and all that may also require some mens rea. Yes, Freduah, your hand is up. You want to speak?
Oh, no, please. It was with
All right, so this will end our discussion. I will meet you again tomorrow because I need to drive back and I live very far away. Okay. Barrister, is your hand up? Barrister, is your hand? Yeah, what is it?
Yeah. Doc, I noticed that I've been missing some of your sessions. I don't know whether, because there are more than one WhatsApp platform, sometimes when you share the link, maybe it doesn't appear on this particular group.
My suggestion is that just type my name on the YouTube. You will see the channel and all the various videos are there. You can go through them. Okay.
Yeah, but sometimes it's nice to take part in the live session. So that's what I'm suggesting, that perhaps if you can make the link available to us in time so we can all be part of the live session.
Okay, maybe another solution is that, yeah, but sometimes the platforms are many and the names are similar. So sometimes copying and pasting, some get lost on you. So maybe what I would suggest is that, okay, on the Facebook, okay, I use Owusu-Dapaah. I will try henceforth to also put the link there. So when you go there, I don't know. Okay, anyway, we'll see whatever works. Okay, all right. Thank you very much. So have a good night. Okay.